Mr. Kenny, just before you carry on, can I just ask, just because I'd like to know the answer, how much longer you think you'll be?
40 minutes.
Thank you very much. You anticipated the question. I hope that that's not chivying. I just was interested to know how long you'd be and when we would start hearing from Mr. Berry.
Just been asked that question by Mr. Berry, so I had a chance to think about it.
Fine.
Not quite as politely as your lordship.
Yes.
We had looked at the RPAD and its discussion of Rodokanaki.
Yeah.
What about the cases that follow? Our submission is, I'm not intending to take you through them in detail, but our submission is that none of them detract from the conclusion in Rodokanaki that as a matter of remoteness, a fact or circumstance may be excluded from account, may not be taken into account. The relevant cases are Agios and Williams, which is in tab 8 of the authorities bundle. That simply approves and applies Rodokanaki. The next is Slater in tab 11, Slater and Hoyle. That again applies it, and although the facts in Slater are more complicated, because in that case the third-party contract was partly performed, so there were questions of causation and mitigation arising from the performance of the third-party contract. It was a less simple scenario than Rodokanaki. I will just draw your attention to one passage in Scrutton, Scrutton's discussion of the cases, which is at page 122 of the authorities bundle. So you obviously recall that in Slater, the seller had supplied defective goods, and the buyer had managed to resell a proportion of the defective goods under a contract with a third party. And the question was, what was the impact on the seller's liability of that contract with a third party? And the passage I'm going to draw to your attention is the black barred passage on page 122, where the judge says, it's well settled that damages for non-delivery or delay in delivery of goods where there is a market price do not include damages for the loss of any particular contract unless that contract has been in contemplation of the parties to the original contract. Horn and Midland. Now, Horn and Midland is not in the authorities bundle, but Horn and Midland is an absolutely straightforward application of the Hadley and Baxendale principle.
Yeah.
It may actually predate the Hadley and Baxendale principle, but it's all about contemplation of the parties. And then he goes on to say the value of the goods in the market, independently of any circumstances peculiar to the plaintiff, is to be taken. And that's Great Western and Redmayne, which we've already looked at. If the plaintiff has a profitable contract to sell goods and there's a market, he can supply himself with goods by purchasing the market. He is then left without the goods he should have received on the original contract and has lost their market value. So that's the third-party contract is ahead of the market. But suppose his subcontract is at a price below instead of above the market price, so that if he delivers goods under the contract, he loses. Can his damages be limited by the amount he would have received on the subcontract? On the above reasoning, it would seem not. And he goes on to cite for that proposition, this has been decided in the case of non-delivery of goods by the Court of Appeal in Rodokanaki and Milburn. So again, it's a discussion of Rodokanaki in the context of, in our submission as an application of, a principle of remoteness. Finally, Hall and Pym, at the next tab, And this was a case where the loss on the subcontract was recovered because it was within the contemplation of the parties at the time of contracting. In other words, classic second limb of Hadley and Baxendale application.
Yeah.
And we only draw your attention to pages 130 and 132, where again the inclusion or exclusion of the subcontract is all treated as an application of Hadley and Baxendale and of ideas of remoteness. Now, I appreciate in this case it was a case where the damages were being enlarged by the application of the second limb of Hadley and Baxendale, so it doesn't take me very far, but again, it's just another illustration that this is a line of cases all about remoteness. Okay, so that is our case on remoteness as we derive the relevant principles from Rodikanaki. I now just briefly want to consider what the respondents say about Rodikanaki and its place in the case law. And I hope I don't do too much injustice to Mr. Berry's presentation if I say that essentially they rely on three propositions. The first is that Rodikanaki is not a case about remoteness, it's an application of an independent res inter alia acta principle. The second is that principle, res inter alia acta, doesn't apply where the third party contract can only be performed with the subject matter of the subject contract. That's Skeleton paragraph 18. And then they go on to say, well, our case is a case like that. And then the third principle is that the res inter alia acta principle doesn't apply in a case of delayed performance. That's Skeleton paragraph 20. And again they say, and our case is a case of delayed performance. You got your ship, you just got it late. Now, our response is that none of these three propositions is right. And as to the first, we just boldly say, no, Rodikanaki is about remoteness for all the reasons that I have developed just before lunch. However, as I indicated at the start of my submissions when Lord Justice Mayer was asking about this, we're not too fussed on this point. If we're wrong about saying that Rodikanaki is about remoteness, and if you were to conclude that in fact Rodikanaki is an application, must be an application of a res inter alia acta principle, then our submission is this, that the only way in which Rodikanaki could be explained in terms of the modern law of res inter alia acta would be to say that the third-party contract with the cargo owner's buyer was an independent transaction, collateral to the subject contract of carriage, so that the effect of that collateral contract, the impact it had on the claimant's loss, was not to be taken into account in calculating the claimant's recovery. If Rodikanaki is explained or analysed in those terms, then one is analysing it in accordance with the law as stated in this court's decision in Doric Valor, which we looked at briefly this morning, and also in the Supreme Court's decision in the New Flamenco. In the Doric Valor, a payment to a cargo claimant, I think I said this morning, its buyer, I actually meant its seller, was an independent transaction not to be taken into account. And in the Supreme Court's decision in the New Flamenco, which is in tab 37 of the bundle, a time-chartered owner's ship was redelivered early. The owner then sold the ship. By doing so, it avoided the sudden and violent depreciation that it would otherwise have been exposed to, with the result that it was net, I think, $9 million better off than it would have been if it hadn't sold. And in that case, the defaulting charterer's defence was, well, I may owe you the normal measure, but you've got to bring into account the benefit of avoiding the depreciation on the ship, to which you would have been exposed if the charter had continued. And the Supreme Court said no causal relationship between the breach of the charter party and the avoidance of the depreciation that the owner achieved, and therefore the benefit of avoiding that depreciation is not to be brought into account. Now, if it is right to say that Rodikanaki is a case about res inter aedes acta, and therefore that it is to be explained as I've just suggested it might be explained, and therefore that it is authority for essentially the same principle as is contained in the Doric Valor and in the Flamenco, then we say, as I touched on this morning, well, the arbitrator's decision that the payments under the MOAs were res inter aedes acta is correct, even if they were, for whatever reason, wrong to describe it as too remote. They were correct to describe it as res inter aedes acta. And in support of that submission, we say that the decision that the tribunal made was to the effect that either the MOAs were independent or collateral transactions of the kind envisaged or discussed in the Doric Valor paragraphs 27 and 28 of the judgment, or that there was no causal connection between the breach of the charters and the payments that the owners received under the MOAs, the absence of causal connection as discussed in the New Flamenco, paragraph 33. And in relation to those conclusions, we emphasize the following facts. One, the MOAs were concluded before the breach. Two, the cause of the payment that the owners received under the MOAs was the relationship between the owners and MSC and NISC, not the charterer's breach. Three, the sale of the ships under the MOAs was a transaction concerned with an aspect of the ownership of the ships quite different from their exploitation as a higher earning asset. Sales were about their realization, the realization of their capital value. And for that contrast between the aspects of the ownership of a ship with which a transaction is concerned, whether exploitation as a higher earning asset or realization of capital value, we rely on comments of Lord Clark in New Flamenco at paragraph 23. Okay, I then have two other submissions to address. The first is the Charter's suggestion that the res inter alias acta principle doesn't apply where the relevant third-party contract can only be performed with the subject matter of the subject contract. All right, and just putting that in terms of the case we're dealing with, what they say is, res inter alias acta doesn't apply because the subject matter of the charter parties was the use of the vessel, and the MOAs could only be performed by delivering the vessels. Now, we say three things in answer to that. The first is the idea that you can draw principles from complex sale of goods cases about the application of res inter alias acta and then transpose them onto a case involving late redelivery under a time charter and an MOA is just fanciful. I mean, the idea that there's some kind of consistent golden thread running through the cases that can easily be lifted out of whatever might have been said in Slater and Hoyle and applied here to exclude the operation of res inter alias acta is just wild. But in any event, the supposed principle is just wrong. Right? Remember what the principle is, that if the contract can only be, the third-party contract can only be performed with the subject matter of the subject contract, then res inter alias acta doesn't apply.
You're back to the case that you postulated before lunch, which was the case where there's no buyer's market because you can't get the goods available at the port.
Yes, you're ahead of me.
Yeah.
Of course. I mean, Rodokanaki itself is that case.
Case, exactly.
All right, so Rodokanaki is a case where the cargo owner had sold the very cargo that was on board the ship to the buyer, and therefore the subject matter, and yet the decision is res inter alias acta or remoteness does apply. And if you want to see that point develop more in a more sophisticated way than I'm able to, have a look at Greer's judgment in RPAD at 165. And the passage we rely on.
Just remind me, I found it.
Sorry, tab 14, 165 bundle 1, the Harry's bundle. Okay, and the passage we rely on, it's clear that in that case, meaning Rodikanaki, the sale was a sale of the specific cargo, and the plaintiffs were unable to fulfill the sales they had in fact made because the specific cargo had ceased to exist. They'd sold the cargo at a price which was less than the market. It's plain that there was no market at that time in which the plaintiffs could have bought the specific cargo he'd sold. He might possibly have bought something as good, but he couldn't have compelled his buyer to take anything other than the specific cargo which he'd sold them. Okay, so that's that point, and then the opposite of the proposition that the charterers are inviting you to accept is said by Lord Dunedin in his judgment in Agios. And if you look at 96, and the passage we rely on is the passage that starts, graciously, the truth. The truth is that the respondent's argument leaves them in a dilemma. Either the subsale was of the identical article, which was the subject of the principal sale, or it was not. And then forget about it was not, because the respondents are relying on it was the identical item. And the relevant bit is, if, on the other hand, the subsale is of the self-same thing or things as is or are the subject of the principal sale, then ex hypothesi, the default of the seller in the original sale is going to bring about an enforced default on the part of the original buyer and subsequent seller. And how can it ever be known what the damages recoverable under the contract will be calculable in precisely the same way as in the original contract? All that will depend on what the subsale is able to make out. The only safe plan, therefore, in the original contract is, therefore, in the original contract, to take the difference of market as the measure of damages and leave the subcontract and the breach thereof to be worked out by those whom it directly concerns. Literally the diametric opposite of the suggestion that is now being made.
That is a res inter alia and not a remoteness analysis, isn't it?
It's the difference between the two is the difference between is a difference of perspective. I think I would occasionally say it's susceptible of either view.
I was just thinking that those whom it directly concerns is almost a translation of the Latin.
Yes, and I accept that. Third point, the charterers rely on a principle that they say can be derived from Wertheim, that res inter alia acta doesn't apply in cases of delayed delivery, and they say that this is a case of delayed delivery because, or is analogous to a case of delayed delivery of sale of goods, because they were supposed to redeliver the ship to us on the 1st of May, and they redelivered it after a delay of 7 days. Now, again, I make my high-level point that the idea that we are transposing conclusions from Wertheim in the sale of goods context into a case about late redelivery under a time charter followed by delivery under an MOA expresses premised on a very high degree of optimism about the transposability of these principles. And we just don't think you can get anything from Wertheim that is applicable to the present case. However, if we were wrong about that, then our submission is that this is not a case of delayed delivery. This is akin to non-delivery. Under a contract for hiring for 10 days, if I fail to make the hired machine available to the hirer for one of those 10 days, the hirer only gets 9 days, and his loss is not equivalent to a delay. He's not getting the same thing only later. He's not getting part of what he contracted for at all. It's like non-delivery of 10 tons out of a consignment of 100. The difference is explained by the fact that under a contract of hiring, the thing that is being sold is the period of time during which the hiring continues. Whereas under a contract of sale, the thing that is being sold is title to the goods. In the present case, where we're considering the late redelivery of a time charter, late redelivery to us by 1 day finally and permanently deprives the owner of the use of the ship for that day. We don't get a day back later on. Therefore, the whole idea that this is akin to late redelivery in Wertheim proceeds from an error of a failure to understand, failure to properly consider the nature of a contract of hiring. Okay, that's all I want to say about Rodikanaki and the Charter's response to that. That takes me to Joyner and Weeks. And again, this is a decision that shows that remoteness, or it might be res inter aedes acta, can function to reduce a claimant's recoverable loss. Joyner and Weeks is in tab 4 of the bundle. The case concerned a lease. The claimant let a property to the defendant for 10 years. Two years before the expiry of the lease, the claimant let the property to another tenant for the period following the expiry of the first lease. The defendant failed to keep the property in good repair and surrendered it in breach of the lease in disrepair. However, in the event, the claimant suffered no ultimate detriment because the new tenant carried out extensive work before moving in. The court held at 42 that the new contract with the next tenant was an accident, which we say again implies too remote, but also said at 45 that the contract with the new tenant was res inter aedes acta. Okay, those are the two cases that we rely on as examples of circumstances which would serve to reduce a claimant's recovery being held to be too remote to be brought into account. We have 3 dicta which we copied out in our skeleton, but which I'll show you briefly if I may. The first is Biggin and Permanite, Devlin's judgment, and the relevant, you remember this was about sales of tar roofing, and the judgment, the relevant passage in the judgment is at 207. And the green bar is his discussion of damages which arise under the second rule in Hadley and Baxendale, sometimes referred to as if they were an increased sum which the plaintiff could obtain if he could show special circumstances, or as if the rule embodied a measure of damage especially beneficial to the plaintiff, which he could invoke if he fulfilled the necessary conditions. It's no doubt true that it generally operates in favour of a plaintiff rather than against him, but I think it's capable of doing either. And what that's presupposing is that circumstances that would serve to reduce the claimant's recovery may be circumstances within the second limb of Hadley and Baxendale, and if the relevant circumstances were not contemplated by the party, those circumstances which would reduce the claim are too remote. That's how the plaintiff would be advantaged.
Going back to Joyner and Weeks, there's a certain amount in it, particularly in Lord Justice Fry, about the advantages of a simple rule.
Yes.
Great practical convenience, and you can try and have an exact measure of damages, but that might have a complexity about it, which it unfits it for determining affairs as between man and man in a court of law.
Yeah.
Very 19th century language. And there's something similar, I think, in Rodecanacci and Milburn itself, where Lord Justice Lindley says these things have to be worked out by juries, not mathematicians.
Mathematicians, yeah.
And I assume that's a theme that you rely on.
Precisely. Yeah. I mean, I will. My parting salvo is labelled commercial pragmatism, and as I emphasised in the context of what we say about the proper rationalisation of the normal measure of damages, the simplicity of our construction of the normal measure of damages is that it applies in every case and dispenses with any need to look at what the owners might have been intending to do. And even Lord Justice Lindley would regard that as a simple rule. So that's Biggin. The second is that the Heron 2, Lord Pearce, and that's at page 283 of the authorities bundle. I just invite you to
Sorry,
read,
what page did you say?
Page 283.
283, oh, thank you.
And I would just invite you to read from the second line. The first part deals with those things that may fairly, and that's, or perhaps from the very bottom of 282, the whole rule in Hadley and Baxendale, and the bit that we particularly rely on is at between E and F, And of course, the extension of the horizon need not always increase damages.
All of that's subject to the Appellants, of course.
Yeah. All right, and then finally, a short and pithy dictum to end. 335 is Justice Carr in the Lily Prima. At the bottom of the right-hand column,
So give me the page again.
so 335, the red page numbering.
Yep.
And he starts, secondly, the line of cases illustrated by Horn and Midland. Horn and Midland is the one we don't have in the authority respondent, but it's a Hadley Baxter case. Has nothing to do with this case. Through obviously to both your examples of raising traders actor and to remote in law. So, those are the dates.
Whose judgment is this?
This is Car J.
Right.
It's reproduced as part of the report of the case in the Court of Appeal.
Yeah.
You get the you start with the arbitrator's decision,
Yeah. Seen
and then
that.
you have Car J's judgment, and then the Court of Appeal. But it's just that dictum that we rely on.
Yeah.
Okay, and we then make three arguments of principle in relation to what we have said about remoteness, or if it needs be, raising traders actor. The first is that our approach to remoteness avoids the obvious injustice that something that couldn't be relied upon to increase our claim should be relied on against us in order to reduce it. This is essentially the point that I made about the MOAs falling through. And in that regard, the point is put, as my Lady Justice Andrews said this morning, at 25 by Lord Esher, page 25 of the authorities bundle, in Rodikanaki. He says, they admit they can't rely on it to increase their damages. They say that because it reduces damage, they can rely on it. He says, I think that if the law was so, it would be very unjust. Second, commercial pragmatism. The point that I have said I am very keen to run up our collective flagpole. The great advantage of remoteness excluding things that reduce circumstances that reduce that would serve to reduce the normal measure of loss is that it simplifies the proof of these claims. It doesn't ever require the owner to prove how the ship would actually have been used, and more importantly, it doesn't require him to prove a net financial detriment, which over any time span may be difficult to prove. And I gave you the example of I missed one time charter, but I get out of the replacement time charter, I get a replacement at a higher rate, but I get out of that later, so I miss an even higher market. I mean, it's just these things. I think Lord Justice Staunton once said, if one's going to anyway, I forget, but he said, if one was to do this, one would have to follow these vessels to the end of their lifespan. So commercial pragmatism, and then finally we say, as a matter of principle, given that we know that causation works in two directions, and the new flamenco is an example of that, certain circumstances which would serve to reduce the claim can be said to be not caused by. It'd be very surprising if remoteness didn't work in the same way. Why is causation a two-edged sword or a two-way street and not remoteness? For those reasons, we invite you to conclude the tribunal were right to say that the MOAs were too remote to be brought into account.
Thank you very much. Thank you. Yes, Mr. Berry.
Good afternoon, my lord. The division of labour on our side will be that my learned friend Mr. Board will deal with the issue whether the claim in this case is in the nature of user damages, that is to say paragraphs 37 to 68 of our the respondent's skeleton, and I will deal with all other issues, in particular whether the by reason of a remoteness rule or a res inter alios acta rule, my learned friend is entitled to claim damages disregarding the MOAs, and also our respondent's notice point that there is authority that this court is bound by or ought to follow that is not materially distinguishable. So, my lords and lady, there is one very simple answer to this case, which is that my learned friend was right in the 7th edition of his book, and that damages for late redelivery under charter party are to compensate for the loss of opportunity to fix in the market. Now note, it is loss of opportunity, not loss of the intention. It doesn't matter what he intended to do. If a plaintiff chooses not to make a market transaction, that is his own decision and causation is broken. You can call that res inter alios act if you like, but let's not do that because that's a particular usage of words that we are going to be arguing about in a minute. So, and that is not only correct, it's been in a textbook that has been authoritative for a very long time now, and just as in the Agios can be taken to be the settled market view of the matter, it is also logical because it is a simple application of the basic fundamental rule of compensation for breach of contract in Robinson and Harmon, which is that you put the plaintiff in the position it would have enjoyed had the contract been performed, and measure the difference between that and his actual position given the breach of contract. So the essence of damages is the counterfactual minus the factual. And to say, excluding, as it were, off-market decisions and frolics. Now, that fundamental compensatory principle for breach of contract inexorably leads to the correctness of what my learned friend said in the 7th edition. Because what you have lost is the opportunity to go into the market. What you have lost is the hire you would have made had there been delivery on time. Now, on our analysis, but not on my learned friends, that can accommodate the 2-day overrun. Because what you are compensating in a 2-day overrun case is the first 2 days of a longer fixture, and in the Johnny there was a divergence whether it is the long fixture is the shortest period you could get a trip, or whether it is a contract for a period of the same length as the contract just expired. And there are different views on that in the Johnny, and Mr. Foxton, as he then was, has written an article saying it ought to be the contract that you would have made, and that needs to be proved. But that's all academic. And the point is that what you're compensating is the lost hire that you would have had you taken that opportunity. And therefore, I invite you to endorse what my learned friend himself said. I'll stop teasing about it, but it's in the 7th edition of Time Charters, which is at page 500. Sorry.
722, is it?
723, yes, thank you.
Tab 41, I think that's the 7th edition.
And that's it, except that, and that is my learned friend's case over in my submission. Now, because he did not have the opportunity because of the contract. It's not quite over, because he will say there is a principle, and whether you call it remoteness or res inter alios acta may turn out to be a semantic debate. But there's a principle that in some circumstances, in assessing whether you had the opportunity, what you've actually lost in the counterfactual, you ignore certain facts. So that is a second stage of the argument, but essentially the first stage of my first argument is that that is the true measure of damages, the true principle behind damages for late redelivery, and it is then only if my learned friend can point out a principle, which I will call res inter alios acta, but he calls remoteness or, and he doesn't mind which, by which you have to exclude certain facts in assessing the counterfactual, and in this particular counterfactual, whether there was the opportunity to use the market. So my simple submission is that is the measure of damages, and in assessing the counterfactual, i.e. what would have happened if not, you do not exclude contracts, save in very limited circumstances, governed by what I will call the rule of res inter alios acta. And I will tell you, and I'll make my submission.
Sorry, governed by?
By what I'll call the rule of res inter alios acta. And the question in this case is really the ambit of that rule. Now, so here, the simple position is that in the counterfactual, he would not have made any higher. And my learned friend has accepted time and again that he has suffered no financial loss. And he suffered no financial loss in this case, not because of some freakish decision of his off-market frolic. He has suffered no financial loss because of conduct which is in the ordinary course of a ship owner's business, i.e. selling his ship.
Just in the same way as if you put it into dry dock, or you decided that he was going to enter into a voyage charter that required him to take it to India.
Yes. Absolutely. That's my point, my lady.
So in all those cases, you say you've got to look at the actual and not the principle.
Subject to caveats about dry dock, which I'll come to in a minute. But yes, and also a following charter. So, but
all the case law that we've seen, in which nobody actually did look at the actual, it's all wrong.
No. Nobody argued in those cases that there was an actuality that made a difference. And as my learned friend says, and my Lord Justice Males picked this up. He said, well, isn't it odd that this is the first time? My explanation for that is that nobody has ever had the courage to claim for a 2-day overrun in circumstances where he had not chartered it for a period to cover that 2-day overrun. This would be unprecedented result in this case. The award is an unprecedented one, so far as I've identified, which is it was a very short period of overrun, which the owner could not have exploited as part of a longer hire fixture, or in any way whatsoever. And yet he gets a notional market value which he could never have experienced. And that...
If you're right, you get the use of the ship for an extra 2 days without having to pay any extra for it.
Yes, my lady, and that is the inevitable result. But not the inevitable result, that is the essence of the capitalist structure of contract. A contract breaker, not being a fiduciary, this is important, my lady, a contract breaker is not obliged to disgorge profits from his breach.
I know. I'm not talking about profit, I'm talking about principle, Mr. Berry.
Well, the principle...
You don't normally breach contracts with impunity and end up paying the same amount of money as you would have done if you'd had an agreement to extend your contract.
When you break a contract, you pay the damages you have inflicted, not the profit you have made. And that's principle. And my learned friend said on a number of occasions, oh, the illegal use they made of it. And he was flirting with the concept that here are these charterers who stole a few days extra use and they ought to be made to pay for that. Well, there is a dispute about whether the last voyage order was illegitimate in the old-fashioned sense of being given without any reasonable expectation of delivery at the final terminal date. And it is certainly not established, and my learned friend's case is not brought on the basis that we were nefarious in that sense, in sneaking a few extra days. But even if the charter was, that does not mean the charter has to disgorge the profit he made on those days. And if it did, the amount of disgorgement would not be the market rate, but his contract rate. So it is a significant error, my lady, to think along the lines of my clients have arrogated to themselves a non-contractual use. Maybe they have, but the inevitable legal position arising out of that is they get to keep that, but they are liable for damages caused, except in those limited cases where you can negotiating damages in cases of that nature, which my learned friend lost below and didn't get permission to appeal. In fact, I didn't ask for permission to appeal. So his attempted claim on the basis of some form of as it were, make my client pay what the reasonable price of the overrun would have been is not open. Can I go back then? So the structure is that the rule in the time charters is compensation for the loss of opportunity to do the market. And I've had a quick look at the 8th edition, and the editor, for obvious reasons, forensic in this case, has hedged his bets somewhat and has said it's all very tricky. Then depends on this case, and I still don't know why it's not up on the website. But anyway. In my summation, take him at his word before the exigencies of this case came into effect. See the 7th edition. And the second thing in my submission is...
Perhaps we could have the 8th edition just out of interest.
I will commission
with
it.
Whatever caveats.
Yes.
I think you're inviting us essentially to disapprove it before it's even been published, are you?
I think my learned friends... I think my learned friends not putting online may be not unrelated to the price, which I see as £638 a volume.
Well, the courses are quite sure it's a bargain.
I'm afraid too late to pulp it. Whatever you say.
That's all right. With mine, I just add a footnote saying the Court of Appeal disagreed.
Now, that being that, my learned friend was right in the 7th edition about the nature of damages, and that analysis was amply supported in my submission by the Agios, and perhaps we can have a look at that, and I'll try to explain what I mean there. But can I just briefly make my submissions on the Agios as a whole before to go into detail? The Agios was a case where actual loss was actually suffered by the plaintiff. In that, the claimant, in that they were they had to agree a reduced rate in the end, and then go back into the market. The case was that the actual loss was much larger than the market rate for the period of overrun, because they had foreseeably contracted for a longer period, and they lost that fixture. So it's a case of actual loss to the plaintiff actually caused by the breach. They lost the more profitable cargo one, and they had to drop the price, and they even missed that, but that's a complication. And the only question in that case was, can they get all of that actually suffered, actually caused loss, because it was actually foreseeable? And the Supreme Court, the House of Lords decision, whether it's a minority or whether Lord Hoffman carried enough people with him to make a majority, came in two parts. Some of them said, no, the actual loss was too remote because it was caused by an unforeseeable spike in the market. But Lord Hoffman and his supporters said, no, because there is a cap on recovery, not just consisting of unforeseeability, but also this concept that you do not accept the risk. So perhaps I could call that non-acceptance of risk. So the decision is, there's no problem about causation in this case, nothing to do with causation. There was admitted causation of a big loss. The question was, can they get all of their admittedly caused loss, given that they were not restricted by one mitigatory rule, because it was unforeseeable, held, no, they can't, because there's another remoteness rule, or part of the same rule, which is non-acceptance of responsibility. So that has got nothing to do with this case. And when Lord Hoffman uses the word res inter alios acta, it might be a synonym for remoteness, but what he is doing is cutting down actually suffered, actually caused damages by reason of some kind of doctrine to which he attaches that label. But in reality, this is what I would call the principle of remoteness. And I will use the words in this fashion. Remoteness, as I call it, is a limiting principle, reducing the amount that you can recover of your actually caused loss. Res inter alios acta is a principle by which, in assessing what your actually caused loss is, certain facts are to be ignored. And the real question in this case is, which facts and in which circumstances? Now, it is true to say that res inter alios acta and remote have been used without that rigorous distinction. And it may be a matter of semantics, which I don't want to get involved in, but for clarity of thought, I invite the court to consider those two different doctrines or principles or rules separately and not be confused by labeling. There's one principle, which I label remoteness, but which is a purely limiting principle. You can't get all of your actual loss. And there's another principle, which is you ignore certain facts at the first stage when assessing what is your actual loss, and don't forget, at the first stage, the general process for assessing actual loss is the counterfactual minus the factual. And so usually, and in this case, the res inter alios acta principle is deployed to require you, or the trier of fact, to ignore facts in the counterfactual. And so here, my learned friend, under the principle of res inter alios acta, which he also sometimes calls remoteness, says, please ignore the MOAs in the counterfactual of what would have happened had you delivered on time. Because if you ignore the MOAs, then there's no impediment to him getting the higher measure, because he would have had the opportunity to rent it out for 6 months, 6 weeks, and there's a debate about whether he gets the 6-week price or the 6-month price. And we say the res inter alios acta principle, properly interpreted, that doesn't permit that in this case. Now, can I with that go, and I'm still under what is the true basis of the rule? It is loss of opportunity. Can I go to the Achilleus, which my submission is that it more than justifies my learned friend's pithy analysis in the 7th edition, and that is at page 544 of the authority bundle, and I think that is probably tab. Somebody tell me what tab that is.
Paragraph 54.
Yes, tab 34, paragraph 54, exactly so,
Yeah.
my lord. But perhaps it take quite a long run up to identify where we've got to here. But if we look at page 544 of the bundle, 79 of the report, paragraph 53A, there's a reference there to the ratio for refusing the claim in this case, extremely volatile market conditions. In other words, the extent of the relevant fall in the market within a short time was unusual, and it stemmed from that unusual occurrence. But it's paragraph 54 that really states the principle. And it's just below the letter C, perhaps. I mean, one needs to read all of this. But so, as both sides agree, the owners had to be compensated for that loss by the payment of damages. But the parties would also have contemplated that if the owners lost a fixture, they would then be in a position to enter the market for a substitute fixture. Of course, in some cases, the available market rate would be lower, in some cases higher than the rate of the lost fixture. But the parties would reasonably contemplate that for the most part, the availability of the market would protect the owners if they lost a fixture. That I understand to be the thinking which relies behind the dicta to the effect that the appropriate measure of damages for late redelivery of the vessel is the difference between the charter rate and the market rate, even if the market rate is higher than the charter rate for the period between the final terminal date and redelivery. And three of their lordships agreed with this analysis, and it is the thinking behind the appropriate measure of damages is that, going back up a line to D, the availability of the market would protect the owners if they lost. i.e., you are compensated for the loss of opportunity to go into the market. Just for your reference, Lord Roger was agreed, Lord Roger's judgment was supported by Lord Walker at paragraph 87, Lady Hale at paragraph 93, and in my submission, Lord Hope at 27, although he doesn't say I concur, he says I found him convincing. So that is part of the ratio. And contrary to my learned friend's submission, this is not a case about awarding you your normal measure, whether you have or not.
Why is it part of the ratio?
Because
The ratio is about foreseeability and whether or not you can recover particular heads of loss. Surely it's an obited dictum about what Lord Roger thinks the parties would reasonably contemplate.
Well, I think it was part of, because of his references to reasonable contemplation, I don't think, I submit it was part of the reasoning leading on to the decision on remoteness.
Good try, Mr. Berry.
But this analysis, subscribed to by 4 of their lordships, or four of the judges, it is that the contemplation is protection by the availability of the market. And that leads to the conclusion that the loss is loss of that availability. Now, I think it's probably worth just looking at paragraph 57 over the page at 545 D to E, and after quoting, Lord Roger quotes the Court of the Gregos, and then Lord Mustill.
So paragraph 67, do you say?
57 at
57, I'm
page
sorry.
545. The implication of this passage is that ordinarily the appropriate measure of damages will be that set out by Lord Justice Bingham the Peonia, since the owners will be able to obtain substitute employment for their vessel. And one go into the Peonia, but the measure of damages is based on the availability of the market and obtaining substitute employment. So in my submission, properly read, the basis of the damages in the Achilles is the cost of a substitute, and that is based on the opportunity to go into the market. Now, that is my submission on the nature of the claim in this case, and the next general submission I would make is that the result here is the clearest windfall profit, and one has to consider quite carefully what principle it is that permits a windfall profit of this nature, contrary to what I might call the general compensatory principle, that a plaintiff is compensated for his actual loss, that is to say, what he would have made in the counterfactual but didn't make in the factual. And I think I'm right in saying that apart possibly from Rodo Kanaki, but we'll have to investigate or inquire into that, and possibly Slater, I don't think there's a single case that my learned friend can rely on in which a plaintiff recovered more than its actual loss by dint of ignoring a mitigating subcontract. And we will, and in my submission, that's not what happened in Rodo Kanaki, and nor what happened in Slater. But with those two possible exceptions, what my friend is trying to do in my submission is unique. Now, the third general point is that my learned friend Mr. Board will deal with loss of use and the like. But I think it falls in this part of the case to say this, that insofar as the charter party itself and common parlance, and indeed pleading parlance, can describe the period of overrun as use, or use in breach of contract, and can also describe the charterer's rights under a time charter party as use of the ship. That means contractual use. To make a difference to the rules on damages, the concept of use and loss of use and wrongful use must, in our submission, be confined to cases based on use and breach of property rights and possessory rights. And that is an important distinction in the whole of this case, my part and Mr. Board's part, which is that there is no element of property at all in the claim or the defence of this claim. And there is a tendency, which I will invite you to resist, to transfer reasoning dependent on property, damages for violation of property rights and possessory rights, to where they do not belong. And the concept of use requires a distinction between contractual use, i.e. the right to have the other side perform services to you, and proprietary use, i.e. possession, at least possession and perhaps higher property rights. They do attract different regimes under damages, But the difference is not in the word use, but is in the concept whether what is being violated is purely contractual rights or proprietary rights. And I'll come back to that in context of the Doric Valor, which establishes this in my submission quite clearly. Now, my learned friend then said, and I think it needs replying to in an opening, he said, there's something to be said for a simple rule and a quiet rule and a quiet time. And in my submission, our rule is just as simple as his rule. Our rule is, as he's read it out, and I don't quibble with the substance or the words, our rule is that a contract is to be taken into account. Sorry, our rule is in two parts. Firstly, the plaintiff cannot get the market measure if the market is not available to him. And the second part of that rule is, in deciding whether the market is available to him, you take into account contracts that can only be performed by using the main contract goods, the self-same goods, but you ignore, as res inter alios acta, only those contracts, subcontracts, that could be supplied by market substitutes. So, two simple rules. One, market rule doesn't apply, just to repeat, if the plaintiff cannot access the market. It's not available to him. And two, in assessing that question, and we're all within causation now, not remoteness, in assessing that question, you take into account, you only ignore those subcontracts that can be performed by market substitutes. And I'll explain the reason why that. But that's a simple rule.
How does that work in the case of a forward fixture, where the owner has made the next fixture, say a month before redelivery,
Well,
at a different market rate from the market rate?
Good question.
Then, well, thank you very much. Then arises at the time of redelivery.
There are two possibilities. The first word, which I submit, is that he gets what my learned friend calls the normal rule. I think the better word is the prima facie rule. And he gets the market rate because, though the fixture was made in advance, it was a forward fixture, what parties are trying to do when fixing a forward rate, in your lordship's example, a month ahead, is to provide a rate that will apply on the date of delivery in a month's time. And if they get that wrong, that is an off-market situation. So this is a case where the normal rule applies.
But it's a case where the owner has disabled himself from actually going into the market at the date of redelivery.
No, he's gone into the market.
Not on the date of redelivery, that's the point.
But he has gone into the market. It is just that he's done so a month in advance.
So at what point then do you assess whether or not the market is available to him, Mr. Berry? Do you look at it through the eyes of pragmatism as to the normal time at which you'd expect to make a fixture? Does that then mean that that if you decide to sell your ship after the date when you would normally be expected to refix it, it makes a difference?
No, I don't think it does. But for the basic proposition, what about a forward fixture? That he gets the market rate because, even though fixed forward, the exercise that he is engaging in fixing forward is to select a market rate applicable on the first day after redelivery.
So does he get, sorry to interrupt you, but I just want to understand the proposition. Does he get the rate that he has fixed forward under that particular contract, or does he get what is objectively the market rate on the date of the redelivery? So he actually ends up, if he's miscalculated, with less than his actual loss?
Yes, because he has miscalculated. And miscalculations in off-market contracts are res inter alios acta. However, if that is not the rule, then equally there's no significant problem or inconvenience, because if that's not the rule, then the result of him having disabled himself from entering in the market is that the prima facie rule is displaced. But that doesn't mean he's uncompensated. He gets his actual loss based on his actual fixture.
So how does it work if a month in advance he makes a forward fixture for when he expects redelivery to be, but something tremendous happens in the world economy and the rates shoot up so that the actual market rate at the date when he gets redelivery is much higher? What, by reference to which rate are his damages calculated?
Well, subject to remoteness, and according to the Agios, an extraordinary event shooting the rates up would, according to part of the majority in the Agios, would take it away. Subject to remoteness, then on my first alternative, the loss, he has been caused the loss of the higher rate.
Even though he can never actually get that higher.
Because he made the mistake, albeit subject to remoteness, and in your lordship's example, it would be too remote. He has underestimated the market rate by going in advance. But I'm not wedded to that solution because, my lord, there are plenty of solutions to such you might put it this way, non-problems as these. These are non-problems. That's my point. The other solution is to say, okay, if he has disabled himself, you look at what actually happened. And my learned friend says, oh, what a terrible big inquiry. It's not. None of these are big inquiries. These are all inquiries that LMA arbitrators do in their sleep every afternoon. Not always rightly, but nevertheless, they do.
Except in cases like this.
So, well, as I said, not always rightly. So, but my lord, the point then is that what is this great, complicated, commercially inconvenient, unpragmatic solution? You say he gets the market rate if my primary analysis is right, and that what they've been doing a month earlier is predicting the market rate on the day of delivery, and they've got that wrong tough. Or you don't, and you say the market rate doesn't apply because he's disabled himself. What was your actual fixture? His actual fixture, as in the Agios, will then determine his actual loss, his actual cause loss, and then you apply remoteness as a cap. And there is no inconvenience, no impragmatism, no nothing problem with that.
Well, you can just see the charter as saying, well, we had no knowledge of this extra fixture. It wasn't something, as in the Agios, of course it would be contemplated that the owners would want to refix after we'd redelivered it. But that is not, to use the words of Lord Hoffman, a risk we agreed to bear when we entered into this contract.
But if that be right, then that would be a reason for capping the damages at whatever the risks were accepted when entering the contract, i.e. as in the Agios. But none of this has got anything to do with what...
said you couldn't get the market rate. This is the point.
You could...
They were trying to get something in addition to the market rate.
Right. But the reason that they didn't get the market rate because it was the market rate. They got the market rate because that was the foreseeable or the capable portion of their true loss. And that's how remoteness works. You suffer a true loss, actually caused. It's capped by the foreseeable, in this case the market rate. You haven't actually suffered the market rate. You suffered a greater, different kind of loss. But the market rate provides the cap. That's just orthodox remoteness. And so, going back to simple rules, our rule is just as simple as my learned friends. And
So if the owners, in this case, had lost their sale contract, so they had actually suffered a loss of the sale contract, which was going to cost them a lot,
yeah,
they would then get the damages on the normal measure at the market rate, would they?
yes,
Even though they never had any opportunity to enter the market.
but they did if they lost their other contract. Sorry, I mean if they lost their MOA.
Yes.
yes, I think they would get the normal measure because they had, in the event, suffered a very substantial loss. Yes, yes. In that situation, as in the Agios, the owner has suffered a very substantial loss arising out of the breach. I imagine your lordship's hypothesis is that they lost the MOA because of the breach.
Yes,
Yeah.
yes, but a cancelling date or something like
Yes,
that.
so they've suffered a huge loss, but they can't collect it all because of remoteness. So what they do collect is the foreseeable loss, which they didn't suffer, because they have suffered a loss which is much bigger. And my lord, that is exactly how remoteness always works, and worked in the Agios.
They recover a loss that they didn't actually suffer because that loss was foreseeable and the loss that they did suffer wasn't.
Yes. My lady, that's exactly how remoteness works.
Mm.
And
Let me just write that down because I'm trying to get my head around it. They would recover a loss they did not suffer, which was foreseeable, rather than the loss they didn't, that they did.
But no, because they suffered a much greater loss that was not foreseeable. Or greater, it doesn't have to be much greater.
As in, you would say Victoria Laundry.
Yes. I'm actually surprised that this is year one remoteness. That sounds a bit. But I'm being driven back to first principles because a lot of what my friend says violates first principles. The next thing he says that violates first principles is that remoteness increases damages. So it is necessary to go back to basics. Anyway, so pragmatism doesn't dictate, and when one's considering inconvenient results, one always has to measure those inconvenient results of the rule as we say it is, with the inconvenient result of the rule that my learned friend says it is, which is a complete windfall. And I'll read you from Wertheim and Chicoutimi in a minute. Now that's Privy Council, and there's a debate about whether it is a status in this court. But it's quite clear that it is a fundamental principle that, say for very good reason, you do not overcompensate people in circumstances where they have not actually suffered a loss. So inconvenience one, it's all too complicated, commercial pragmatism, we dispute that. Our solution is just as, or similarly commercially pragmatic. And in every case, my lord, there will have in any event to be an inquiry, or at least unless it's admitted, into whether there was a market and whether it was available or not. And one of the factors that will come into that debate is whether the plaintiff, the claimant, had any contracts that barred his own access to the market. So this is all wrapped up in the question of whether the market is available to the claimant. And I say again, this is the sort of inquiry that courts and arbitrators do very frequently. The dry dock case is very similar. The dry dock case is no problem at all. It's a non-problem. Either you give the owner the normal measure on the basis that he's planned for a dry dock and he's planned what one would presume for a fixture following it, and he has planned, therefore, a market rate which covers the dry dock period but with a delay, or you say, because he has disabled himself from entering the market, it's a real loss case, not a prima facie loss case, and there's no problem whatever with that. And you don't have to inquire to the end of the world, because we know from the Agios that you only have to inquire for those days up to the end of the actual fixture.
So the days can you explain what you mean by it's a real loss case? What is the real loss?
The real loss is that if he's 2 days late going into dry dock, he will be 2 days late coming out, other things being equal, and he will have really lost the 2 days at the other end rather than at the beginning. So there's a real loss there. And the only niggle is...
What if he gets the yard to work overtime?
That raises a completely different area of law, which is mitigation. So, my lord, there are three things which need to be separated, although they do overlap. The first is remoteness. Remoteness is a limiting factor that caps your damages based on what you can foresee as at the date of the contract. And according to Lord Hoffman, what you're deemed to accept as at the date of the contract. So that's remoteness relating to foreseeability of the date of the contract. But then there's causation, which is as at the date of breach, certainly in contract, as at the date of breach. And you take into account everything that happened up to the date of breach, foreseeable or not, to work out what loss has been caused by applying the counterfactual minus factual. So that causation is, these are rough divisions, but causation takes into account factors up to and including the date of breach. After the date of breach, it's mitigation. And it is, in my submission, important to keep those three things in mind. They apply at three different stages, and there are three different concepts. So, in answer to my Lord's question, if the ship owner chivies the yard along, then he's mitigating. And if he mitigates successfully, then any benefit from successful mitigation is, because of the rules of mitigation, credited to the wrongdoer.
So he's
subject to the costs of...
So on that scenario, he gets the costs of the overtime.
Yes. Yeah. And well, he suffers a real loss in that amount, and he can probably get that under the mitigation rule that you can recover damages for the cost of mitigation. But those are separate, independent bases for recovery than the one I'm concerned with, which is what was caused by the breach, subject to mitigation. And what was caused by the breach is the key to this case, and that is the counterfactual minus the factual, assessed as at the date of the breach, although that's not an invariable rule. So part of the problem, my learned friend confuses mitigation with causation, and he's confusing two stages there, and it is possible to confuse causation with mitigation, and I invite that to be borne in mind. So dry dock, positioning voyage, that's not a problem either. Because either you treat the positioning voyage as revenue earning by applying a time charter equivalent analysis, which is done every day. And I think it's right to say that on spot fixtures, that's how these things are accounted for. You take into account the ballast voyage, the positioning voyage, you take into account the freight for the actual voyage, you round the whole period up, and you ascribe the days of the approach voyage a financial benefit being their proportion of the whole. So no problem, the normal measure applies there to the positioning voyage. But if, because you suffered a loss. Unless
the owner says, speed up a bit, in which case you mitigate, you say, and just get the extra fuel consumption.
Yes, that's a result because he has spent money on mitigating away his loss, which is the fundamental basis of mitigation. And the disponent owner is not a problem either. Because a disponent owner is, if he is precluded from going back out into the hire market because he has to redeliver it to his owner, then he's unable to go into the market. If he suffers an actual loss, for example, by being sued by his own head owner, then once again you are into a standard remoteness situation. He suffered an actual loss. It may or may not be foreseeable. One doesn't know if the position of disponent owners were known at the date of the contract, but if it wasn't foreseeable, then he suffered an actual loss, but he recovers that as capped by the foreseeable. So there are no inconvenient consequences of the rule as we have it, and certainly none that match up against the extremely inconvenient consequence of giving these claimants a huge windfall. Now,
so on your positioning voyage, the owner orders the ship to speed up, but because the ship is 2 days or 7 days later than it ought to have been, it runs into bad weather, which it ought not to have encountered, and you have a dispute as to whether there's been successful mitigation or not.
Yes.
Is that your approach?
Well, that's a very simple legal scenario. It's whether the bad weather was approximately caused and foreseeable as to whether the claimant can recover damages for it. You take into account the bad weather in assessing his actual loss, but of course you take into account whether it was foreseeable or not in deciding whether to cap it on mitigational reasons. Again, no theoretical problem at all. I mean, there might be evidential problems, but there always are. What I'd like to do is to make five five submissions of partly of principle and partly of what is an issue in this case.
Sorry, 5 submissions, partly principle and partly...
Of principle, yeah, of principle.
Or principle.
Which lead to what the real issues are here.
Yeah.
The first is that causation and remoteness are different principles, completely separate. The first is what loss did you actually suffer, applying the counterfactual minus the factual. The second is how much of that can you recover, and the answer is only so much as was foreseeable and or you accept a responsibility for. And never the twain should meet. And but they do, in my learned friend's case, he confuses remoteness with causation. And can I invite you to, for this purpose, to look at Professor Treitel in tab 48 of the Authorities Bundle, page 781, dealing with the very important case of Slater, of which my learned friend showed you the most important page. But triggered by the case of Bentz. And he starts by saying, and this applies to my learned friend's submissions in the nicest possible way, I might say, discussions of damages for breach of contract suffer from an unfortunate tendency to treat Hadley and Baxendale as governing more aspects of the problem than were actually an issue in that leading case. One illustration of this tendency is Bentz. And then the objectionable part is the Hadley-Baxendale principle is a recovery of true loss and no more or less, namely to put the complaining party, so far as money can do it, in the position he would have been if the contract had been performed. With respect, says the professor, it would have been more accurate to say that the effect of Hadley and Baxendale is often to put the victim of the breach into a position less good than that in which he would have been before if the contract had been performed. That was probably the natural result of the decision in the leading case itself, where the plaintiffs no doubt suffered loss of profits in consequence of the stoppage of their mill, but the court took the view that the damages were not recoverable in respect of that loss. The principle is not one of recovery of true loss, no more or less. The case also shows that in discussing damages for breach of contract, it is necessary to distinguish between many questions. For example, one has to ask first what the injured party has lost. Now that's causation. And you apply the counterfactual minus the factual. And then, for how much, if any part of that loss, he can recover damages. Now that's remoteness. Under the rules of remoteness, the answer to the second question depends on the reasonable contemplation test associated with Hadley and Baxendale as interpreted in later authorities, and that means the Heron 2, and I would also add now, and the Achilles development. But the answer to the first question has nothing to do with that test. Simply depends on whether the injured party is worse off as a result of the breach than he would have been if the contract had been duly performed. If he is, and if that loss is not too remote, we go back to the same question, the further question will generally arise how that loss is to be quantified, blah, 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 reasonable contemplation. The test is one of remoteness alone, it is not a panacea. A reasonable contemplation test, that test is one of remoteness alone, not a panacea for solving all or even most questions of contract damages. Now, Now, really, not only is that impeccable, but it is an answer to this concept that remoteness increases damages. I'll come back to that article because it explains properly the Slater case, but that is different. And the other point is that causation, the first stage, really, the proposition that causation, the first stage, has got nothing to do with remoteness is illustrated by the marine star. So if I can ask you to look at that in the authorities bundle, tab 29, page 418. And rather than read it out, I can just summarize it. This was a case of a breach of. This was a case of non-delivery of oil, but it was held that the buyer who suffered the non-delivery, there was no market available to him, and I cite it for two propositions. The first proposition is that in dealing with causation, the question 1 of Professor Treitel, foreseeability is irrelevant. And I cite it for the second proposition, which I'll come to in a minute, which is that you have to inquire in every case whether there is an available market to the plaintiff. And so if we then can turn to page 424 of the bundle, or perhaps we should start at 423 in the right-hand column at the bottom, very bottom. Defendants submitted that for the plaintiff to maintain any claim for loss of profit or damages based on any measure other than the cost of purchase replacement.
Sorry, hang on.
Sorry, beg your pardon.
424.
Yes, but
Yeah.
I've gone back to 423.
I'm sorry.
Just to give
That's
a little.
why I couldn't find
Sorry,
where you were
sorry.
reading from.
Just to
The
give a little
defendant
run-up.
submitted, is that what we're looking at?
Yes,
Yeah.
but I don't actually need that part. So what I do, the defendant submitted that for the plaintiff to maintain any claim to loss of profit or any damages based on any measure other than the costs of purchase and replacement, they had to establish that it was within the contemplation of the parties when they contracted that there would, in the event of non-delivery, be no available market for acquiring the replacement goods. I reject that submission as a matter of principle. First, it finds no support in the Sale of Goods Act. Now, subsection 3 is couched in terms that indicate the only factual inquiry is whether there is or is not an available market. If there is, then the prima facie measure under subsection 3 applies. If not, then the general measure in subsection 2 applies. In other words, recovery for loss of profit is only possible if and when the parties have contemplated resale on terms which give rise to such a loss, but even then it is not possible if there is a market available to the buyer on which the innocent party could have brought in against the defaulting seller. That's put it the first proposition. It doesn't matter whether the market in the causation stage, whether it was foreseeable or not that there would be no market. In the causation stage, it just depends on what actually happened in the events, whether there is a market. And then a little further down, just after the big black bar and the citation of McGregor, the formulation of section 5051 of the Act proceeds on the basis that there may not always be an available market for a replacement purchase or sale. In parenthesis, that itself seems to me unsurprising when, as in the present case shows, the lack of an available market may result not from any particular intervening event, but from a combination of market forces, a tight contractual delivery date, and late repudiation by the defendants leading to a situation in which no replacement goods are available. And then he goes on. And so if we go back up the page, which I read out, to just in the middle of the thick black line, but below the upper thinner black line. In other words, recovery of loss of profit is only possible if there's a market available to the buyer. So, for the market measure to apply, there has to be a market available to the buyer, and in deciding that, remoteness foreseeability is just irrelevant. Now,
how does that translate? I mean, this is all about sale of goods. How does that translate to loss of use of a profit-earning chattel?
Good question, my lady. ever since Wertheim and Williams and Agios in 1911 and 1914, which are sale of goods cases, and Slater in 1920 something, the courts have analogized from Rodokanaki, which was carriage of goods, to sale of goods, and have sought to apply general principles that cover all. This case is one step further, which is analogize all of that but there's this common theme that in all of those different areas, the question is, do you ignore an actual fact in your factual assessment of what loss was caused on the grounds of, there have to be some principal grounds, and I will call it the principle of res inter alios acta. My learned friend can call it remoteness if he wants. And that is a common theme across all areas, and in my submission it is valid to look at what is said in the sale of goods areas and the carriage of goods area with due adjustment for the differences to the time charter area, because the fundamental nuts and bolts of the question are the same. One party has suffered a breach of contract, but could, or at least in theory, have gone out into the market to mitigate's the wrong word. I've just cautioned myself against
But
that.
a major difference between the sale and carriage cases on the one hand and the charter party case on the other is that the former are concerned with fungible goods, so that if you don't get 100 tons of soybeans when the ship goes down, or when the ship is late, you can go and buy 100 tons in the market with which you can perform your subcontract if you've got one.
Yes.
And therefore, as a matter of causation, the loss which you suffer is
It's the market.
the market loss, and the fact that you could go and perform your subcontract if you want is neither here nor there.
Yes. And
But that's a causation analysis which
Yes.
works because the goods are fungible.
Yes.
Whereas in the charter party case,
They're not.
You can't go and get another ship, however wonderful it may be, and to perform your next fixture because you've only chartered a particular vessel.
Well, subject to those cases which say or sub. but
Indeed,
yeah.
yes.
Yes, my lord. And that is the very reason why that rule of ignoring subcontracts does not apply in this case, because we are not in the fungibles.
Yes.
That's my case. The rule of excluding some things only applies where they're fungible. The subcontract can be performed by fungibles. Otherwise, you have to look at what actually happened. That's my case in one sentence. My main case, I have subsidiaries. But just to elaborate, the rule of res inter alios acta, or remoteness, by which you ignore things, only works when there's a market by which you can supply the subcontract, because then as a matter of causation, that's what you ought to do, and that's what you're deemed to do. And if you go off and do something wacky, that's your own problem.
Well, you're expected to do it in order to mitigate your loss.
Yes, you are. You are. Absolutely. So the rule as I propose it is also a fundamental application of the principle behind the mitigation rule, which
Depending
is,
on which way the market goes.
of course, which is you're deemed, if I can put it this way, you're deemed to do the right thing in economic and moral terms with your subcontract, which is to perform your subcontract, if you can, with the main contract goods, and if you can't, to buy in the market. And only if you can't do either, which is our case here, then you need an inquiry into your actual position. So the Marine Star, title plus the Marine Star establishes that causation is irrelevant, foreseeability is relevant to causation, and remoteness is relevant to foreseeability, but that's a cap. And this is where my learned friend says, oh, it's so unfair. It's so unfair that I can rely on something to reduce the causation and he can't rely on it to get the damages. It's not unfair. It is a necessary consequence of the rules on causation and remoteness, in particular the rule of remoteness, that you cannot get all of your loss, always. Nothing unfair about it at all. It has a spurious attraction to say that you can't use fact X in causation if you can't use fact X in remoteness. But it's false reasoning, because in remoteness you are addressing something different. Should there be a cap on what you get? In causation you're addressing what have you actually suffered, i.e. what would you've got in the counterfactual. So this plea, I'm tempted to say whinge of unfairness, is entirely off the critical path. Second general proposition. In contract, generally, damages are to compensate the plaintiff for its economic loss by comparing the counterfactual contract performed with the actual contract not performed. Now, I've said that several times, but that's a fundamental principle which is important. And that is the compensatory principle in Robinson-Harman. In my submission on that's what Lord Roger applied in the Agios, they were applying the compensatory principle, and that is a principle that defeats my learned friend's claim, unless there's an exception to it. Third proposition, there is, however, a different compensatory principle in cases of loss or damage to goods, that is to say, violation of property or possessory rights to tangible property. There's a different area, and it is very important not to transport rules from that area to the other area of contracts which do not involve that. And I submit that the time charter party is not a contract that involves violation, or late redelivery is not a wrong that involves violation of possessory or proprietary rights. In the case of loss or damage to tangibles, the rule is not Robinson and Harman. The rule is not that you economically compensate the plaintiff for the difference between the counterfactual and the factual. It is a very importantly different rule, which is that you restore, if you like, the value of the property that has been either lost or damaged, and one could debate delayed. And this is engraven on every first-year pleader of a cargo claim. It doesn't matter who actually suffers the financial loss, as long as you've got the owner of the good at the time, and even since the Act, not even then. And the way of illustrating this is by the Doric Valor, tab 40, which is based on the Sanix Ace, which my lord said was a judgment of a master of shipping law, and I endorse that for what it's worth. And
all of us would endorse that as well.
and it's at page 717, para 36 at the bottom right. The next case, the Sanix Ace, was a claim under a voyage charter party. The charterer was the FOB buyer and so on, to whom property and risk passed on shipment. Cargo was damaged during the voyage as a result of the entry of seawater. The cargo was sold on to separate receivers. Under these sale contracts, risk passed on shipment, but the property could not pass until appropriation to the individual receiver. Because of the damage, that never happened, so the property and the cargo remained at all time with the charterer. Nevertheless, the charterer succeeded in obtaining full payment of the price payable under the contract of sale with receivers because it was in a position to prevent conforming LCs. The shipowner's argument that this extinguished the charterer's loss was firmly rejected. And perhaps we can pass over the first passage because I can't remember which council it was, but whatever his argument was unsustainable. It's this. This argument is patently unsustainable, and I did not feel it necessary to call upon the claimant's counsel. It has been long settled law that the owner of goods is entitled to sue and recover damages in respect of the loss or damage to those goods. The only qualification is that if he's suing in tort, his claim may be defeated if his title was bare proprietary one and did not include any right to possession of the goods. In English law, it is the claimant's property in the goods which gives the right to recover substantial damages. In tort, the title to sue and recovery of substantial damages are concurrent. There's no such thing in the relevant context as the right to sue in tort for merely nominal damages. In contract, although nominal damages can be awarded, the right to recover substantial damages can be proved by proving possession or ownership of the relevant goods. The carrier's argument before me that the claimant suffered no damage because they were subsequently paid is misconceived. As soon as the goods are damaged, the owner of the goods suffers loss. Formerly, he was the owner of goods of full value. Subsequently, he's the owner with only a reduced value. He has suffered a loss. While he may not be able to recoup that loss from others is a separate question. And, my Lord, the passage, I think, that puts it to rest is, let me see if it's in here. No, but perhaps I should then go to the supplementary bundle for the for a passage next to that. I'm sorry about that. I thought I could do it from there. Supplementary bundle, tab 1, that's Annex ACE itself. Yes, it's at pages 4 to 5 of the bundle. And perhaps we start at the bottom of the right-hand column of page 4. Similar decisions are collected in Article 194 of Scrutton.
Sorry,
Sorry.
page
4 of the bundle.
Yep.
Bottom.
Yep. Similar
right
decisions.
column. Similar decisions. Yeah.
Yep.
That the fact that the claimant or plaintiff has contracts of sale or purchase which enable him to collect the price from the buyer or obtain reimbursement of the price or other compensation for seller do not disentitle him from recovering full damages. Full damages assessed by reference to the sound arrived value of the goods are not affected by the fact that the owner of the goods has sold them on at a higher or lower price. Right? And that is the rule that my friend so heavily relies on. All the cases demonstrate the principle that it is the loss to the proprietary or possessory interest that is compensated, not some other or different economic loss. And then the Aliac one. And that's right. But the point is, in damage to goods, tangible property, you are not compensating the plaintiff for his economic loss under the normal rule in Robinson and Harmon. You are restoring the value, if you like, objective value of the damage or the lost goods. What that means is you cannot reason from the rule here, where the object of compensation is restore the proprietary interest, to a case which does not involve damage to property or property rights. You cannot transport willy-nilly the irrelevance of the owner having sold them on a higher or lower price, because the basic rule of compensation is different in the two cases. And
If they are different rules of compensation, then why is the Res inter alios Act principle needed in the damage to goods instance? It's not needed at its basic level, but a principle of res inter alios acta, or a different part of the principle, which is that if you do something off-market to the goods, true causation is broken. The res inter alios acta principle is just a principle of causation, really. Yes.
And it's needed for those cases where the owner does something, where the goods owner does something that is actually a novus actus. But the core principle, what are you trying to compensate, is different for property cases and pure economic contract cases. And the res inter alios acta principle, therefore, has different tentacles in the two. But in the pure economic case, something is res inter alios acta only if you can supply it in the market, because then that's what you should do. If your goods are damaged, the right thing to do is to buy sound goods and supply them to your subcontractor. If the goods have sunk, the right thing to do is to buy a new cargo and give it to your subcontractor. And more doubtfully, and in my submission, delay cases are actually different to see work time. In a delay case, it is arguable that you ought to buy goods that you can timely deliver to your subcontractor, but it is my submission that Wertheim decides that these principles do not apply at all to delay cases, and res inter alios acta has no role to play at all in a delay case, at least where the goods arrive later and are accepted. But so second principle, there's a different compensatory principle, which, because of the very nature of what you're compensating, renders irrelevant, and you can call them res inter alios acta, and they have been called res inter alios acta, but it renders irrelevant subcontracts for the sale of the goods. And so my Lord Justice Mail says you don't need a res inter alios acta principle for that purpose. And my submission is yes, but you can't stop people using those words for where they're not properly justified. And there are other res inter alios acta parts of the principle that do apply here. If the owner does something wacky off market with the goods. So I'm not addressing that, but in a case where there's an off-market contract, something idiosyncratic, that's a different branch of the res inter alios acta principle, which is not engaged here, and I don't want even to go there, because what the owners did in this case was perfectly ordinary in the normal course of the business of a ship owner, renewing its fleet, updating it, and it just wasn't foreseeable, but it wasn't abnormal, and it wasn't off-market. So those are the three principles. The fourth principle is that the market measure is only applicable if the market is available to the plaintiff. And we've seen that from the Marine Star, but it's also, there's plenty of it, it has to be available to the buyer, to the plaintiff. And my learned friend, and there's always going to have to be an inquiry before you apply the market rate measure. Not always, because in some facts it'll be simple. But there's often going to be an inquiry into whether the market is available.
No, but the inquiry with respect is usually whether there is a market rate for this type of transaction. It's not whether the market rate is available to this particular person.
In my submission, it is both. There has to be a market rate, but it also has to be available to the normal person in his situation.
That's what you're putting on it, but I, for one, would like to see some authority for the proposition. That when you're looking at the market rate, you also encapsulate within it whether it's available to a particular buyer.
The particular, a buyer with the particular characteristics.
Of this particular
I
person.
thought well, I submit that that's what the Marine Star says when it refers to the market being available to the buyer. But I can see that might not satisfy your ladyship, so I'll do that overnight. But it would be an odd application of the market rate rule if, for reasons that are not idiosyncratic, and obviously idiosyncrasies must be left out of account, if, as in the Marine Star, for reasons of the shortness of time or the whatever, the market was not available to that particular buyer, it would be very an odd rule if the market principle was applied in circumstances where, through, if I put it this way, no fault of his own, he couldn't access the market. But, my lady, perhaps I'll take that under advisement, as they say, overnight. But my primary submission...
To see if you dig anything up, because it seems to me to be a novel proposition. It may well be right, but it does seem to me to be a novel proposition.
Yes, well, okay, I thought, yes, okay. Well, my submission for now, that I'll try to do better, is that the Marine Star makes that clear when it refers to there has to be a market available to the buyer. Our primary point in this case is that it isn't, because of the MOAs. And foreseeability has nothing to do with that, because as per the Marine Star and as per title, foreseeability has nothing to do with what loss you've actually suffered. It doesn't have to be foreseeable that it's not available to you. Now, and then I come to the punchline. We accept that even that if we accept that in deciding what loss you have suffered, stage 1 of the inquiry, it is sometimes the case that you ignore a subcontract. And that, finally we come to it, the rule of res inter alios acta, the one that my learned friend really relies on. And what is that rule? As a matter of authority and as a matter of principle, it is that you only ignore those contracts that can be performed, subcontracts that can be performed by a market substitute, as I submitted to my Lord Justice Males a little bit earlier. And seen that way, it is really an aspect of causation. Seen that way, it is a rule that does not permit for windfall overcompensation, because the presumption is you go out into the market and satisfy your subcontract, and you have therefore bought at the market rate, and that is your loss, so there's no overcompensation. It is economically sound in that it requires parties to perform contracts. It is morally sound because it requires parties to perform contracts. And it is, this is slightly more controversial, it explains every single case in the bundle with due reference to other explanatory factors. So that's it. The rule is, the res inter alios rule is you only ignore a contract, a subcontract, if it can be performed in the market by this plaintiff.
And sorry, is this principle 5?
That is the answer to.
Yeah.
That is the.
We had 5.
Yes, that was 5.
And that's 5. I appreciate that it's
it's
principle. It's all been leading to that, but that's your.
This is my
That's your
punchline.
plea.
This is my punchline, my lord.
No, it's
I
just,
said
it's just for the dull headings in my.
I put it as 5 is the question. When do you ignore a contract, subcontract? And my answer is when it's can be supplied in the market. And that's what you feed into the question 4: is the market available to this plaintiff? So Rhoda Kanaki, in my submission, Rhoda Kanaki is interesting only because it has been deployed in sale of goods cases. Of itself, it is a claim for conversion against a carrier, but also a claim for breach of contract in destroying, losing the charterer's goods. It is a property damage claim within the Sanix Ace principle. At least it would definitely so be explained now. And we are applying the law as it's understood now. And if we see page 15 of the Authorities Bundle, tab 3, and I remember below, my Lord Mr. Justice Bright kept asking me to show this case to him, and I kept saying, but it's got nothing to do with it, except it's been, and so I'm not going to make that mistake here. In the end, Mr. Bright showed it to him. So my submission is this is irrelevant, except to the extent adopted in sale of goods cases. And if that doesn't make them relevant, then it's completely irrelevant. If my lady says that what's all this got to do with charter parties, I would subscribe to it and say there's no res inter rule in charter parties. Anyway, the plaintiff chartered the ship, defendant's ship, which I think was called the Reedsdale, for a carriage of cotton and so on. The 10 lines down the headline, the cargo is lost by the negligence of the master. In an action for non-delivery of the cargo, the jury found that there was no special custom at Alexandria, so there was an issue about what terms applied to the contract of carriage. Then under the held, the first 10 lines are about the customary terms. And then just above the second held, the plaintiff having sold the cargo to arrive at a price less than the market value of the goods at the port of discharge, at the time when the cargo should have arrived, held in estimating the damages, such market value must be looked to, and the price at which the plaintiff had not the price at which the plaintiff had sold the cargo. So you ignore the lower price that the plaintiff actually sold the cargo to at, and my learned friend founds on this case, and he says that is an example of ignoring an unforeseeable subcontract which reduces the damages. And this is the case he would apply in the present. But your Lordship may notice at the bottom of the page, the action was upon a charter party by the plaintiffs as the charterers and cargo owners. And so this was a claim by the owner of the cargo. This is a Sanix Ace claim. And so it is irrelevant what loss the actual cargo owner suffered, and in particular, his on-sales are irrelevant, as stated by Lord Hobhouse in Sanix Ace. Why? Because what one is compensating in this class of cases is not the economic loss of the plaintiff, but the depreciation to the cargo. So this case has got nothing to do with our case. This lays down no principle. It lays down, you can call it a resident, and it was called the res inter alios acta principle, but it's res inter alios acta in this case because the inquiry about what the plaintiff suffered is irrelevant, and therefore his contracts are irrelevant. So it's res inter alios acta, but for that special reason here. The second reason why it's irrelevant is, in my submission, this was a case of a fungible cargo which could have been bought and substituted in for the subcontract. Now here, this is my second and unnecessary reason for saying this is irrelevant, but here I accept there is a divergence of subsequent Court of Appeal dicta. Lord Justice Scrutton, in both Slater and the UPAD, said that this subcontract was a contract for similar goods, i.e. not the very thing on board the Redesdale, whereas Lord Justice Greer said the subcontract was specific to the goods on the Redesdale. And Lord, we've investigated all the extant reports of this case below and in the Court of Appeal, and I commissioned, unfortunately Lloyd's list does not go back that far, and an attempt to look at the Times for March and April 1886 has not produced any fruit either. So we do not know the terms of this actual subcontract. But what we do know, at page 17 of the bundle and at 69 of the report, and at the top, is that after the second paragraph at 17 of the bundle, after the execution of the charter party and before the shipment of the cargo, the plaintiffs had sold the cargo to arrive at a price less at the port of discharge. Now, in my submission, that means it must be a generic contract because the contract was made, contract for generic goods, because the contract was made before shipment. So the contract cannot say cargo now on board the Redesdale. It's an open question about whether the contract said cargo to be delivered to arrive ex Redesdale or contract to arrive in the month of whatever. We don't know. And Lord Justice Greer thinks it was the latter, Lord Scrutton thinks it's the former. But everything Lord Isha said is in that context that, of course it's res inter alios acta, because you're not inquiring to the plaintiff's actual loss. And anyway, insofar as it's fungible goods, he could have gone out into the market, should have gone out into the market to supply his subcontract.
But there wasn't one.
Well, maybe there wasn't.
I thought that was the whole point, that there wasn't a market for this particular cargo at the place of delivery. So the only goods that could have been delivered under this contract was the, whatever it was, milled linseed or cotton or whatever it was.
I don't think that appears from this judgment. I think that's how it's explained by, in a later case.
Right.
Because
I picked it up from somewhere.
because they were talking about the
Mr.
market
Kenny told
price.
us that there was a seller's but not a buyer's market.
Was that this case?
I was relying on Lord Justice Greer,
Yeah.
and that's what he says in his judgment.
There's no basis whatever for any of that in the actual judgment,
Right.
or below, or in the other three reports that we looked at.
Perhaps Lord
And
Justice
Lord
did
Justice-
have access to something that
Well,
we do not.
Lord Justice Coulson says the opposite. And perhaps he had access. I checked whether he was the pupil of Mr. Manisty or Mr. Well, either Mr. Finley, Mr. Gorell Barnes, whoever. So yes, can I just? So
Lord Justice
that's
Foxton would be able to take the answer to that.
well, yes. Well,
Lord Isha does say that upon getting the goods, he could sell them.
yes.
Might be inconsistent with a sale of the specific goods to the buyer.
Yeah.
Because if he'd sold the specific goods to the buyer, he would have disabled himself in the same way that has happened here.
Yeah. So that's a hint in my favour.
I mean, it may be reading more into that
Yeah.
comment than is really there.
Can I show? I'm going slightly out of order, but can I show Slater first and then go back to? No, I better show Wertheim first and go back to Slater. Yeah. But so pausing the moment because Lord Justice Scrutton explains, at least provides his explanation of Rodokanaki and Slater, but maintaining the chronology. Can I invite you to look at Wertheim? Time? Probably not.
Hang on a minute. So
Yeah.
I'm writing down pause, come back to Lord Justice Scrutton in Slater.
Probably tomorrow.
Yeah.
And it might not be a good time for me to embark on Wertheim either because that takes more than
No,
a
I
few
think
minutes.
that may be right because that crops up in the skeletons considerably. I have a quick look at that. That's one because of that. So, I mean, you made good time.
Our current expectation, Mr. Board and I, is that we will be done by the short adjournment tomorrow
Yes, I was
with a possible slight spillover.
fine. Well, let's try and work on stopping at their short adjournment, but if there is a possible spillover, then so be it. All right, well, we will pause there then, Mr. Perry, if that's all right, and we'll come back at 10:30, and I hope everybody's been warm enough. We've had terrible problems with the heating in this building. I refuse to come into courts that aren't reasonably warm. This seems to me to be reasonably warm, but sometimes people say, well, it's all right for you up there, it's somehow warmer. But it's been all right?
There are no complaints about it
Well,
being too
that's-
cool from here.
That's one thing. At least we've achieved that. All right, 10:30, thank you.
Sometimes it's been too
Court line 81.